TCC Judgment 113 宪判 3, 2024. Case on the criminalization of public insult 1. And notes, Article 309, paragraph 1 of the Criminal Code, which stipulates that public insults are punishable by short-term imprisonment or a fine, is proportionate and does not violate the constitutional protection of freedom of speech, so long as the punished act of public insult entails 1. Insulting speeches that are given publicly and purposefully to hurt another's reputation to the extent that it exceeded what a general person could reasonably tolerate. And second, under the balance of interest between the offender's freedom of speech and the victim's reputation, the latter is more worthy of protection. The term insult in the disputed provision, whose meaning can be deduced by a court through general legal interpretation, does not violate the principle of legal clarity, the principle of clarity and precision of legal provision. Background note, Article 309, paragraph 1 of the Criminal Code stipulates a person who publicly insults another may be sentenced to short-term imprisonment or a fine of not more than $9,000. A question arises as to whether imposing criminal punishment for public insults is compatible with constitutional protection of freedom of speech. There are 24 petitioners in this case, half of whom were found guilty finally under the disputed provision, and the other half are judges or court panels who question the constitutionality of the provision when hearing public insult cases. The petitioners argue that 1. The term insults in Article 309, paragraph 1 of the Criminal Code is unclear, thus violating the principle of legal clarity. Second, a speech would not harm the reputation. A speech being found insulting only reflects the subjective judgment of the listener. Criminal measures are not the least restrictive means to protect the right to reputation. And fourth, the disputed provision may lead to a chilling effect on freedom of speech. In addition, some of the petitioners also filed constitutional complaint against the final court decision in which they were convicted for the offense under disputed provisions. Summary of the judgment holding 1. Article 309, paragraph 1 of the Criminal Code, December 25, 2019 version, stipulates a person who publicly insults another shall be sentenced to short-term imprisonment or a fine of not more than $9,000. The act of public insult, punishable under said provision, entails in the context of individual cases, insulting speeches that are given publicly and purposefully to hurt another's reputation to the extent that it exceeds what a general person could reasonably tolerate. It also entails that another's right to reputation is more worthy of protection than the offender's freedom of speech after balancing the speech's impact on another's reputation, its contribution to the public discourse, its positive value in academic or professional fields, and whether it amounts to literary or artistic expressions. Within this scope, the dispute provision does not violate the protection of freedom of speech under Article 11 of the Constitution. Second, the term insult in the disputed provision does not violate the principle of legal clarity. Third, the intent of the petitioner nice constitutional complaint, the part where Taoyuan District Court Criminal Judgment 110 Qianxiang 573 2022 dismissed the petitioner's appeal against being found guilty of public insult is unconstitutional. The said decision should be quashed partially with the relevant matters remitted to a Taoyuan District Court. Fourth, in terms of the petitioner tense constitutional complaint, Taiwan High Court Criminal Judgment 111 Xiang Yi 1671 2023 is unconstitutional. It should be quashed with the relevant matters remitted to a Taiwan High Court. Fifth, in terms of the petitioner 11's constitutional complaint, Taoyuan District Court Criminal Judgment 110 Qianxiang 505 2022 is unconstitutional. It should be quashed with relevant matters remitted to a Taoyuan District Court. 6. In terms of petitioner 12's constitutional complaint, Taiwan High Court Criminal Judgment 112 Chang E 651 2023 is an unconstitutional issue because it was relevant matters remitted to the Chaoyang District Court. Reasoning 1. In terms of the Part 1 of the holding, 1. Constitutional rights pertaining to the review. Article 11 of the Constitution inscribes that the people's freedom of speech should be protected. The purpose of this article is to protect the free communication of speeches, which enables people to gain sufficient information from the self-regulated and pluralistic marketplace of ideas. People doing so may express themselves and further realize their personalities, promote the discovery of truth, the dissemination of knowledge, and the public discourse of civil society. Under the protection of freedom of speech, the people can effectively put the government under public scrutiny, which aids in the development of democracy. However, this does not mean that speeches of all kinds are all unrestricted. When a person's speech undermines another's right or public interest, the legislator may, conforming to the requirement of Article 23 of the Constitution, impose constraint on speeches as appropriate. Such constraint hold the offender accountable in terms of civil, criminal, and administrative responsibility. The disputed provision imposes criminal punishment on certain content of speeches under the ultima ratio principle in criminal law. When reviewing the constitutionality of such a measure, special consideration should be given to whether the positive effects pursued by such criminal punishment are obviously bigger than the damage of limiting the freedom of speech. This is to prevent the court and the prosecuting entity from overly intervening in the free communication and debates between people in private disputes that does not concern the public interest. Second, review of the provision's purpose. With reference to the provision's legislative history and judicial practice, the provision's purpose is to protect people's right to reputation, especially the personality rights guarded under it. Under the jurisprudence of this court, the right to reputation is an unenumerated constitutional right under Article 22 of the Constitution. In theory and practice, the protection of it could include a person's social reputation, honor, and dignity in personality. Social reputation, also called external reputation, is what others objectively think of a person. Honor is what one subjectively expects or feels of his or her own reputation. Dignity in personality entails a person's societal subjective status respected and treated as equal by others. Since discrimination or depreciation, a person's equal subjective status is related to the person's development in personality and the equality between members of the society, which should be considered as the core of the protection of personality rights under the right to reputation. Personality rights or the right to the free development of one's personality concern a person's freedom as a subject of right to decide, form, and develop his or her personal morals and characteristics. It is an unenumerated constitutional right that contains personal reputation under its scope of protection. The right to reputation can be seen as a specific personality right, as it derives from the substantialization of general personality right in the sphere of societal evaluation. In this case, this court only has to review the protection of the right to reputation, especially the part where it covers the protection of dignity in personality, instead of reviewing personality right repeatedly. In terms of the social reputation, whether a public insult is potent enough to tarnish one's actual social reputation depends on the context of each case. Criminal punishment is not necessarily needed if an insulting speech only undermines one's fame or merely causes one's actual social reputation in apparent damage that can be cleared by the marketplace of ideas. Employing criminal measures against the insulting speeches to protect people's actual social reputation, however, is a legitimate legislative purpose. In terms of honor depends on a person's subjective feelings, which cannot be verified. It will be hard to foresee or ascertain the literal scope of the term insult if added honor under the protection of the disputed provision. Therefore, the constitutional right to reputation does not protect one's feeling toward his or her own reputation. C. In terms of dignity in personality, a person's subjective status is connected to the person's personality development and the peaceful coordination of a societal communal life, which also concern public interest. When a person from a structurally powerful group demeans the identity or qualification of another person from a vulnerable group, it would not only demonstrate the offender's hostility or prejudice against the group and its member, but also affect the substantive equality of their social structure, position, and power relations. This type of insult has a negative ripple effect in society instead of merely infringing private interest. Therefore, an intentional public insult that demeans another's character may degrade the person's equal subjective status and further cause substantive damage to his or her personality rights. To conclude, the purpose of the disputed provision is constitutional so long as it protects a person's social reputation or dignity in personality from being damaged by another's insulting speech. 3. Review of the provision's measure. Although the disputed provision's purpose is constitutional within the above-mentioned scope, this court should still review the provision's measure in terms of the reach of its application and whether the punishment conform with the ultima ratio principle in criminal law. This is to make sure that the positive effect of the provision outweigh the negative effect of restricting speech. A. The textual scope and the implication of the term public insult in a disputed provision may be overreaching and should be limited as appropriate. There is a risk that the textual scope of implication of the term public insult in a disputed provision may be unduly restrictive of the freedom of speech. This risk arises from the fact that the punishment may be overreaching due to the lack of stable criteria and may be unduly interfering with an individual's use of language or may penalize negative speeches, which also serve a function of public discourse. Considering the constitutional protection of freedom of speech, the act of criminal public insult entails, in the context of individual cases, insulting speeches given publicly and purposefully to hurt another's reputation to the extent that it exceeds what a general person could reasonably tolerate. It also entails that another's right to reputation is more worthy of protection than the offender's freedom of speech after weighing the competing factors, such as the speech's impact on another's reputation, contribution to the public discourse, and the positive values in academia and artistic fields. Within this scope, the disputed provision conforms to the protection of freedom of speech under Article 11 of the Constitution. To elaborate on the above-mentioned criteria, in addition to referring to the speech's context, factors such as the offender's personal condition, the status of the offended, the relationship between the two, and the incident involved should also be taken into consideration. Accidental and unintended insult out of indignation or a slip of tongue should be distinguished from intentional direct insults. Furthermore, speeches that are merely offensive and do not do much harm should not be considered reasonably intolerable. Because being offended is inevitable in common social life, negative remark would meet the criteria of exceeding what a general person could reasonably tolerate. If they cause mental anguish, that leads to detrimental mental effects or self-denial of another's dignity. Negative remarks on public affairs through distressing to certain people may still be valuable for public discourse. The same goes for speech concerning another person's academic and artistic performance. The value of these negative remarks should be considered in context instead of being punished directly for public insult. The deterrence effect provided by the disputed provision conforms with the ultima ratio principle in criminal law. Under the ultima ratio principle in criminal law, offenses that are punishable by criminal measure in principle should be limited to antisocial conduct that damages the public interest. If a publicly issued insulting speech has harmed another's social reputation or dignity in personality beyond the extent that a general person can reasonably tolerate, it is not merely offensive but antisocial. This is especially the case when the speech is intended to degrade the person's structurally vulnerable character, e.g., race, gender, sexual orientation, disabilities, and further undermine his or her equal subjective status as well as dignity. The legislative decision to punish such speech with criminal measures provide a general deterrence effect, which does not violate the ultima ratio principle in criminal law. The disputed provision includes short-term imprisonment as one of the options for its statutory punishment. Although short-term imprisonment may be commuted to a fine, under the constitutional principle of proportionality in sentencing, it could still be draconian to deprive a person of bodily freedom solely because of the person's speech. Short-term imprisonment should only be considered for severe public insult cases, such as online or digitally transmitted insult that cause continuous, accumulative, and viral harm to the victim. In terms of the judicial remedies of the petitioner's original court cases, even though the disputed provision is constitutional within the scope mentioned above, petitioner 128 final court decision shall be remedied if not conform to this judgment. Under Article 92, Paragraph 2 of the Constitutional Court Procedure Act, applying Article 91, Paragraph 2, mutatis mutandis, these petitioners may petition the Prosecutor General for an extraordinary appeal if they believe the final court decision of their cases violate this judgment. The Prosecutor General may also file an extraordinary appeal sua sponte if he or she believes any of the decision violated this judgment. Second, in terms of Part 2 of the holding, the term insult in the disputed provision, it is a value-dependent indefinite legal term, which may raise the question of clarity. However, as it is viable for the court to interpret and apply such an indefinite legal term in individual cases, the provision is not in violation of the principle of legal clarity. 3. In terms of Part 3 to Part 6 of the holding, the disputed provision is constitutional within the scope shown in Part 1 of the holding. However, in terms of the constitutional complaint lodged by petitioner 9 to 12 for individual cases against their final court decisions, this court has reviewed the decision following the factors mentioned above and found all 4 of them unconstitutional. These cases shall be quashed, with relevant matters remitted to each of their courts of jurisdictions.